Back to our immigration coverage right now. Some immigrants trying to get a green card by getting married could be deported. This is a look at the policy notice that was put out by the Department of Homeland Security. The policy also applies to immigrants seeking lawful permanent residency through other family members. Joining us now to put all of this in focus, immigration attorney Gustavo Mora. Thanks so much for joining us once again.
Sure. Hi, Colleen. How are you? Thank you.
Good. Now, this change applies to pending requests on August 1st or later. Are there people who applied before all of this? They could still be granted a green card?
Yes, of course. And moving forward, all of the individuals that are applying for adjustment of status can also be granted a green card. This is just the immigration office raising the stakes and making it a little more difficult for individuals to apply for an adjustment of status. That's why it's so important to get the message out that if you are going to move forward on something with the USCIS affirmatively, you should contact an immigration attorney to help you out because of the risk of being sent to immigration court.
And Gustavo, Kathy Vara here. An NBC News analysis found that more than 500,000 petitions were filed by family members in the first half of the year. So what happens to all of those petitions?
So again, all of the petitions continue. This is just giving the officers more discretion on whether or not they're going to be able to be efficient or inefficient in this process. Specifically, they don't have to issue, moving forward, requests for evidence or notices of intent to deny and can simply deny the case outright. They also have the option, discretionarily, of course, of sending the case to immigration court. But again, with the assistance of an immigration attorney, there are still ways to present this case, but the bottom line is that it's going to cause a lot more inefficiencies because these cases, if they are sent to immigration court, are going to require a lot of time and coverage by not only an immigration judge, but also by an attorney with the Department of Homeland Security, as well as private counsel.
Gustavo, a lot of people think you automatically become either a U.S. citizen or are entitled to a green card if you marry a U.S. citizen. Can you walk us through that process?
Sure, and I appreciate the question. Persons that have legally entered the United States or persons that are protected under Section 245I of the law, which had a petition prior to 2001, are allowed to apply for a green card in the United States, generally, on family petitions. Individuals who don't meet those two requirements can apply for a green card through the consulate from their country of origin. So they have to actually leave the country, and in many respects, many instances have to use a waiver, what's called an I-601A waiver. So for persons who are applying here in the United States, those are the ones who would be most concerned. And specifically, it's the I-130 petition, the visa petition, the family petition filed by a spouse or a son or daughter to the individual that will come under the more scrutiny thanks to this new policy. So that's why it's important to make sure that you get all your ducks in a row and do the most effective, comprehensive application possible when you file affirmatively with immigration.
Great information there, Gustavo Mora. Thank you so much for joining us.
Thank you. My pleasure.